Mr. Cox, do you see me?
I can hear.
I guess I'm doing this right.
Oh, Your Honor, I apologize. I came to the office just to let everybody go. We've got COVID in the office. I'm going to have to go to the house. I'll pick up on a Zoom from the house.
All right, good morning. This is the November 24th docket evidentiary hearings, the 294th district court. I'm going to call this morning's docket. Please say present or here when I call your name, and then I'll recall the cases for announcement from counsel. Do we have Mr. Kyle Casey at the jail? Mr. Casey, if you can just raise your hand. You can see and hear me. Thank you, Mr. Casey. Mr. Files, that's your client, correct?
Yes, sir. If the court wishes me to, I can go home and be back in code tied about 20 minutes.
No, sir, that's okay. That's okay. And Mr. Earlston, are you there with us? Mr. Earlston's here. Mr. Ashmore's here. Antonio Lano. Mr. Lano, you're appearing by Zoom. Mr. Stuckel is here. I'll recall your case in just a moment. Tanya McBride. Thank you, Mr. Nicholas. Mr. Palmer. I saw Mr. Palmer also. Mr. Red's here. Mr. Green's here. William Wilson. Mr. Wilson, if you'll raise your hand, you're here. And Mr. Perkins, I see you. All right, looks like we have everyone here. All right, let's see. Let's go with Mr. Perkins. Are you ready on Mr. Wilson?
Ready, Your Honor.
All right, Mr. Wilson, if you'll make your way to the chair in front of the camera so that Mr. Perkins can see and hear you. All right, Mr. Perkins, I believe that we are set on 3 cases today from Mr. Wilson, CR 19-327, which is set for arraignment on bail jumping, failure to appear, CR 18-522, tampering or fabricating physical evidence, and also CR 18-521, evading arrest with a vehicle. It's my understanding, Mr. Perkins, that you have filed a motion to withdraw as representation in this case. Is that correct?
That is correct, Your Honor.
And is the basis of that one being Mr. Wilson's request?
Yes, Your Honor. What happened, if the court remembers, this was set for a plea sentencing. The probation office got in touch with me and told me that Mr. Wilson had failed to appear to do his PSI. We showed up in court. Mr. Wilson didn't show up, which I assume is the basis for the new failure to appear case.
So your motion to withdraw is based on him failing to appear?
It's based partly on that, and he's in violation of his attorney client privilege, and also he's in violation of his employment contract with us, Your Honor.
Mr. Wilson, you understand that Mr. Perkins has filed a motion to withdraw before the court. Are you in agreement with Mr. Perkins withdrawing as your attorney in this case?
No choice. I had no choice but to agree, sir. I don't really know what's going on. I'm really confused about a lot of this stuff, and I just hoping for the best. I give it to God. I really don't know what's going on.
Well, let's make sure that you know what's going on. So what I heard Mr. Perkins tell me was that he was your attorney. He set it for a plea or sentencing, that you were scheduled to appear at the probation office to conduct your pre-sentence investigation report, that you did not appear, and you did not appear in court, and it appears that you have been indicted for that failure to appear, and you have received a new charge of bail jumping. And Mr. Perkins has indicated to the court that you're not paying him. Does that help you understand what's going on?
Yeah, I do understand stuff. It just that, I understand, sir.
Say that last part again.
I understand, sir.
Okay, so you understand everything that Mr. Perkins said, and now you're up to speed. So what is your intention? You do have a choice on whether or not you want to agree to Mr. Perkins withdrawing as your counsel.
Well, I know, but if he don't want to be my attorney, then I had no choice but to have to agree, because I wouldn't want somebody to represent me that don't want to be my attorney.
Well, what I'm heard Mr. Perkins say is that it's not that he doesn't want to be your attorney. It's just that he wants to get paid for the work that he's doing.
I had my family to contact him, and I let him know that he would get caught up. My sister said she would help me to catch him up by the 1st, but he was not in agreement unless I paid it off before the day. So I'm not able to do that, and just going by good faith for somebody to help me on the street, sir.
So if Mr. Perkins is allowed to withdraw today, what is your intent on having counsel? Are you going to hire someone else to represent you?
I just hope that you maybe can bless me with a court-appointed attorney, because I'm just straight indigent, and I'm just going by the good faith, someone out there to help me. But as of now, I'm just under the mercy of your court, that you see that I can maybe get a court-appointed attorney.
Well, the way that I would bless you, as you say, or I would go about giving you a court-appointed attorney, is that you would have to request a court-appointed attorney.
I would like to request a court-appointed attorney.
And that means you're going to have to fill out some paperwork, and I'm going to have to review it and find out if financially you meet the requirements for court-appointed attorney. If you do not meet the requirements for court-appointed counsel, are you going to hire one to represent yourself?
Yes, sir. I've already filled out one, because I didn't know, could I try to get a hold of Mr. Perkins, saying, I've been locked up 6 months already. I've been trying to get a hold of him, and, they wouldn't receive my call and stuff to find out what was going on since I've been locked up. But, I'm disabled through the state, so I'm disabled all the way around, and I'm not able to work or.
When's the last time you completed the paperwork requesting?
It was probably like almost a month ago, about 3.5, 4 weeks ago, when I got here, because I was in Smith County. It took them 5 months to get me over here just for the charge for here because of the COVID. And then I filled one out when I got here, and I've been in Canton, Van Zandt County, almost about a month now. So I filled it out the next day that I got here.
Mr. Perkins, have you discussed the indigency issue with Mr. Wilson?
I have not, Your Honor, and I don't know what effort Mr. Wilson has made to contact us. I feel like we're pretty easy to contact. We've got the same address, same phone number, everything. Even during this pandemic, we've got people answering the phone.
Well, it was just every time I called, my call was rejected. And I got my sister to call and talk to Ashley, your assistant, and let her know that I was calling. And she said that I was not able to talk to you, and like I was trying to talk to you before, until I just couldn't talk to you. And unless I had the money that I was trying to talk to you now before all this happened. And she said that unless I paid all the money up before the court date, that you was going to withdraw. And I really like you as an attorney. You're a really awesome attorney, and I really need you. And I just.
The problem, Judge, that I have now is that even though I think it's unlikely, I've got a conflict, or at least a potential conflict, on this new failure to appear case. The bail jumping case, they could actually list me as a witness. And so, that's the reason where I told Mr. Wilson's family when they contacted us that we had to be paid in full and that I doubted my ability to represent him on this other case because of the potential conflict. And so they decided, I guess, not to pay anything. And so that's where we are. He's, and I don't have the exact figure in front of me, but I would say thousands of dollars in arrears with me.
And
That's all right, Mr. Wilson. The court's going to grant Mr. Perkins' motion to withdraw. Mr. Perkins, you're hereby relieved from representing Mr. Wilson in this case, and you're free to go.
Thank you, Judge.
Mr. Wilson, I'm going to set you for a status hearing on your request for appointed counsel.
yes, sir.
Review your paperwork. If I find that you meet the requirements for court-appointed counsel, then I will point that individual to you and send you paperwork and information about that. In the meantime, however, I'm going to reset your case. Today is November 24th. I'm going to reset you for December 3rd. So that'll be next Thursday. And we'll revisit this issue if I have not appointed you an attorney. Do you understand?
Yes, sir.
All right, Mr. Wilson, go ahead and have a seat in the back. Thank you, Mr. Perkins.
Thank you, Judge.
Mr. Files, are you ready on your client, Mr. Casey?
Yes, Your Honor, we are.
Mr. Casey, if you'll make your way to the front, please. Yes.
Paperwork, the conditions of probation, because Mr. Casey is not here. I'm not really sure how we want to go about facilitating that, but there, that is.
All right, the state has just handed to the court a document entitled Motion to Withdraw the State's Motion to Adjudicate Guilt. The state has indicated that there's an agreement to extend the community supervision period for 1 year, that Mr. Casey would serve 15 days in the county jail as a condition of probation, with that time being served from October 28th through November 11th. And that would also continue him on community supervision. Is that correct, Ms. Heisel?
Yes, Your Honor.
Is that your agreement, Mr. Files?
Yes, Your Honor. He has been continually in custody. My legal assistant who has his case is out with COVID, and I could not find the number of days that he has been in custody since Van Zandt County's put a hold on him, but it's significantly more than 15 days. I talked to Ms. Curry yesterday about whether or not her understanding from our agreement was it'd be 15 days from today or 15 days from the time Van Zandt County wanted him. And she apparently has no objection to his getting credit for the time.
Yes, on the document, they have listed the dates as being October 28th to November 11th. So a couple
That's correct. She was not certain that he was still in custody, and we assured her that he is, and he obviously has been.
And Mr. Casey, do you understand that if the court approves this extension, that you would have other requirements, such as you would have additional court costs of $50? You would also, during your extension, you're going to have continued requirements to pay your supervision fees, your UA fees. You understand all of this. You've talked with your attorney about this, and this is what you want to do.
Yes, sir.
And this would extend your community supervision period until November 6th of 2022. You understand that?
Yes.
All right. And court will, based on the state's motion to withdraw, the court will grant the motion and will order that Mr. Kyle Morgan Casey, that his community supervision be extended for a period of 1 year to end on November 6, 2022. He's ordered to serve 15 days confinement in the county jail with credit being received from October 28th through November 11th of this year. And Mr. Casey is ordered to pay additional court costs in the amount of $50 associated with the filing of the state's motion to adjudicate. Or the state grants and signs the order. Now, Mr. Casey, do you want to sign that, Mr. We need to have go out. Mr. Casey. Yes. Is it RJ? All right, so Mr. Casey, I'm going to have a member of the Community Supervision Department come to the Van Zandt County Jail, and you're going to sign this amendment to your conditions of community supervision, which is the document that puts into writing everything that we've discussed today. Do you understand that?
Yes, sir.
My signature will be on here. You're going to sign here, and then you can get a copy of this from your probation officer. You understand?
Yes.
All right, the court has signed the order. All right, thank you, Mr. Casey. And I believe that resolves everyone that's in the jail court today.
Yes, sir.
So thank you. Thank you, Deputy. I appreciate your help this morning.
Yes,
Kind
sir.
of once again, would apologize for not being properly attired. That's a first for me. I appreciate the court's patience.
You're welcome, Mr. Falls. I appreciate it.
Thank you, sir. All right, and Mr. Stuckel, are you ready? Mr. Plano?
Yes, sir.
All right, if you'll come on up to the podium here so your client can see and hear you. All right, this is cause number CR 20134, State versus Antonio Lano. And I believe that we're set for a status on the CPS records today. Any update from the state?
Your Honor, at the request of Mr. Stuckel, he filed a motion requesting CPS records. I filed a subpoena a few weeks ago requesting those records. We received them in our office last week. It is roughly 1,600 pages of CPS records. Ms. Heisel has those with her this morning. She provided them to Mr. Stuckel. However, those records are unredacted CPS records. After consulting with Ms. Curry, what we've decided to do in order to save everybody some time so that this doesn't keep getting kicked on down the road, and to save the court from having to read through 1,600 pages to determine what needs to be redacted and what doesn't, I've gone ahead and given Mr. Stuckel those unredacted CPS records. However, as a part of that agreement, and I'm sure Ms. Heisel's discussed that with him this morning, we are requesting that he not make those records available to anybody outside of his office, that he not reproduce them in any way. We feel this will save everybody some time, and again, save the court from having to go through 1,600 pages, or the state to file a motion for an in-camera review. So I just want to put that on the record that we are providing Mr. Stuckel with the records, but that they are unredacted, and we are requesting that he agree not to reproduce them in any way or make them available to anybody besides his client or outside of his office.
Your Honor, just for the record, we do have that agreement canonized into writing, and I have given it to the clerk to be file marked into the record, and I have turned those records over to Mr. Stuckel.
So y'all put that agreement in writing?
Yes, Your Honor.
And it's followed with the clerk?
Yes.
In addition, Your Honor, when I originally filed this motion, I did file a prospective protective order I believe the court has that in its records. If not, I have a copy of it, and the court is welcome to have that signed as well. But I fully understand the agreement with the state regarding unredacted records and not to make any copies, not to disseminate them. And obviously, I will follow that.
All right, then the court will let your agreement suffice in
Yes,
this
sir.
matter. So I believe, okay, so let's go ahead and set. It's going to take you some time to review. And we were set for a status today, but we haven't made it past pre-trial. Is that correct?
I believe that we have.
That we have. All right, so set this for Dr. Call. January 7th. Do you believe that would give you enough time, Mr. Suckle, to review those records and be able to announce to the court on the 7th whether or not there will be an agreement by way of plea or request for a bench trial or a jury trial?
I believe so, Your Honor. Is there a plea deadline in this court?
It would be on that docket call date.
On the
So
January
on the 7th, if all pretrial issues are resolved and all negotiation has been had between the state and defendants, then I would just look for an announcement of either ready and a request for a bench trial or a jury trial, or you can announce to the court that you've reached a plea and you can enter it that day, or you can request the court to set you for a plea later than that day.
Yes, sir.
So, Mr. Lano, I'm going to order you to be present in the courtroom on Thursday, January 7th at 9 a.m. You understand that this is the only notice that you're going to receive from the court? All right, and can you take your device off mute so that I can have your announcement for the record?
Okay.
All right, Mr. Lano, do you understand everything? Did you hear your attorney, and did you hear the state
Yes, sir.
with regards to the records? And you also heard me inform your attorney that I was going to set this case for docket call on January 7th at 9 a.m.
Yes, sir.
This will be the only notice that you received. So if you fail to appear on that date, the court will issue a warrant for your arrest and a bond forfeiture unless there's some justifiable reason.
Okay.
Okay?
Yes, sir. Understand.
All right, so we'll see you on January 7th at 9 a.m.
And Judge, if we do not come to a disposition on that day, if we request a plea to set at a later date or something other than that, may I appear by Zoom on January 7th?
Yes, you can appear by Zoom, but Mr. Lano is going to be ordered to appear in person.
Yes, sir.
Yes, sir. Yes, sir. And Mr. Lano, you're free to go.
Thank you. Thank you.
All right, court call CR 20135, State versus Tanya Lucretia McBride. Ms. McBride, if you will, raise your right hand. I'm going to place you under oath. Ms. McBride, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. Yes, please. All right, the written plea admonishments don't indicate whether there's a plea agreement or an absence of a plea agreement, so we don't have that. Sorry, Your Honor, it's approaching.
Check the box.
Yes, sir. And is there an agreement with regards to the disposition for the sentence, just not the restitution amount?
That's correct, Your Honor. There is an offer for 10 deferred that I believe is an agreed amount. It's just determining the amount of restitution.
All right, I think that needs to be reflected in here. Right now it says that there is no plea agreement, other than there's a plea of guilty, waiver of jury trial, final hearing on restitution. And I believe if it's going to be deferred, we need to put that in here. She needs to be admonished of that. It needs to be acknowledged.
Sorry, Judge, I missed that.
It's okay. If that's what she's accepting, if she's not accepting anything and she just wants to plead guilty today, and there's still negotiation going on regarding the sentence or the restitution, then what I would suggest is just do a waiver of jury trial and let's set it for a plea and work those issues out. But if she's wanting to do the 10 deferred today and have the restitution hearing later, then we need to have the documents.
That was the agreement between us and the state yesterday, Judge. Just moving too quick this morning.
Yeah, so
Apologize.
just right here where it says 10 deferred, let's have her initial those things since she's already signed it.
I'm okay with it. We want to ask the judge about that. Judge, Ms. Heisel has made a suggestion, and it seems to make sense, that we'll just do the execution of the waiver jury trial, just for the fact that we don't have probation conditions and want to bog proceedings down any further. So we'll just come back on a short reset if that's all right, Your Honor, and we'll do that.
We have no objection to just taking the jury waiver today and then coming back once the full terms of the agreement have been signed off.
Do we anticipate that we're going to have an agreement on the restitution amount, or are we ultimately going to have a contested hearing on this?
We anticipate an agreement.
We still just getting numbers? put together from the alleged victim?
Your Honor, I'm going to let Mr. Cox speak to that. This is his case.
Judge, there's a significant amount of restitution in this case. I believe it's into the six figures. It's my understanding from Mr. Ashmore, he would like a hearing on, he would like a hearing for the court to determine exactly how much his client's going to be responsible for repaying as a condition of her probation.
That's correct. Yeah, that's what we discussed yesterday.
So we don't anticipate an agreement on restitution.
Well, I don't think we will.
I was cautiously optimistic, but it is a significant amount of restitution, and I represent a young mom who's, I don't want to put her on a course to failure and disaster either, with a $110,000 demand from the victim.
The state's going to bring witnesses to prove up the amount that's being alleged, Mr. Cox.
Yes, sir.
So we need to set this for another evidentiary day. We don't need to set it for a plea. We don't need to set it for a plea on a regular docket. We need to set it for an evidentiary hearing day and take testimony.
That's probably.
Yes, sir. The December evidentiary date, if that's available.
Mr. Ashmore, are you wanting your client to waive her right to jury trial today? Or is she wanting the court to waive her right?
She's in agreement with that course of action, Your Honor.
So, Ms. McBride, I've already sworn you in?
Mm-hmm. Yes, sir.
Okay, good. So, Ms. McBride, you understand that you have the absolute right to have your case tried before a jury of your peers. You understand that?
Yes, sir.
That's a constitutional right that no one can take away from you. You understand that?
Yes, sir.
And if you invoke that right during that jury trial, you'll also have the right to cross-examine and confront the state's witnesses and their evidence against you.
Yes,
You
sir.
understand that by waiving your right to a jury trial, you're also waiving your right to confront their witnesses and contest their evidence in front of the jury. Still confront it and cross-examine it before the court, but you would lose that right before a jury. Understand that?
Yes, sir, I do.
And you understand that by waiving your right to a jury trial, there's really just very limited circumstances in which that right can be restored to you. Meaning that once you waive it, it's hard to get it back.
Yes, sir.
And have you thought through this decision? Have you discussed it with your attorney, Mr. Ashmore?
I have, yes, sir.
And are you doing this of your own free will in the court?
I am.
No one's threatened you, forced you, or pressured you to waive your right to a jury trial.
No, sir.
You understand what you're doing here today, is that correct?
Yes, sir, I do.
And Mr. Ashmore, you believe Ms. McBride to be competent today to make this decision?
Yes, Judge.
All right, the court then, based on the evidence, will approve the waiver of jury trial for Ms. McBride, or will grant the waiver of jury trial, and we will set Ms. McBride for an evidentiary hearing. Consulted the docket before we set a date. Set Ms. McBride then for a contested hearing on the restitution amount on December 17th at 9 a.m. Mr. Ashmore, if you'll fill out that notice of appearance, let her sign that, then she can be free to go. Ms. Heisel, I'm going to return this paperwork back to you. I'm going to keep the waiver. Ashmore, are you ready on Christian Earlston, CR 2116, or do you need more time?
We're ready, Your Honor.
Do we have any paperwork associated with that?
Yes, Your Honor.
Is this case still an open plea before the court?
It is, Your Honor.
Are we anticipating testimony today?
We are, Your Honor.
And about how long do you anticipate, Mr. Ashmore? Ties off any witnesses from the state?
Your Honor, I would defer to Mr. Cox on that, but I don't believe so.
No, Your Honor, we don't have any witnesses today.
Yes, This paperwork will need to be sworn by the clerk. But before we do that, let me ask. I see in the written plea admonishments that on page 2, under the following plea agreement exists between the state and the defendant. Is there an agreement between the state?
Your Honor, there is agreed cap in this clause, but there is not an agreement as to final petition.
Okay, and what does that mean? There's an agreed cap. That means you're agreeing not, or the state's agreeing not to argue more than an amount?
Yes, sir, Your Honor. We're not going to request that the court sentence Mr. Earlston to any more than 12 years TDC.
So it's just an argument. Mr. Earlston's aware, Mr. Ashmore, that as indicated on page 3, that the court can assess any punishment within the range, that you can't cap the court's consideration of the full range of punishment. But the cap, I just want to make sure he understands that the cap is just they're agreeing to make a recommendation to the court, but that's not binding on the court. Does he understand that?
Yes, you understand. Yes, Judge. We've spoken about that multiple times over the last 5 days, this morning, in addition to the weeks and months leading up to that.
Okay, so we'll need this to be sworn by the clerk if we go any further. And this will need to be sworn as well. before we begin, I want to place something on the record to discuss with council and Mr. Earlston. As a member of this community, I attend church at the First Baptist Church here in Canton. And due to my attendance at that church and my involvement in the community, I do have personal familiarity with the defendant, Mr. Earlston, by way of association with his family in the church setting. So I know his father, I know his stepmother, I know Mr. Earlston. I've been involved with him in the youth programs at our church. I'm also familiar with the alleged victim in this case, the sister of Mr. Earlston. With that known association, the court has weighed on whether or not it believes that it could be fair and impartial in this case. And I have no concerns about my ability to be fair and impartial about receiving the evidence and applying the law to the facts and rendering a sentence in this case. With that being said, that's the court's position. Mr. Ashmore, if you're more comfortable with me recusing myself and having another judge appointed to hear this case from Mr. Earlston, I will do that voluntarily. And so I just wanted to disclose, I haven't disclosed that prior to this time because I felt like we needed to get on the record together and have this discussion. I have no concerns. However, if you have a concern, and I'm sure that I would hope that you have already spoken with your client about that, because I'm assuming your client's already discussed that same issue with you, Mr. Ashmore. If he has not, then I would encourage you to have that discussion with him at this time.
Respectfully, Judge, that was one of our first conversations, and we're still in agreement that we want to proceed before Your Honor, despite the personal familiarity. We are very appreciative of the disclosure, but it's been something we've known about since I've been his attorney, and I am correct in saying my client is nodding his head in the affirmative that we can proceed.
And from the state, Mr. Cox?
Judge, that's fine with the state, Your Honor. We have no issues with the court's impartiality.
Mr. Cox. Okay. All right, Mr. Earlston, if you will, you can remain seated. If you'll just raise your right hand, I swear you at this time. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, put your hand down. And bailiff, the microphone keeps going off. If we can just keep that on.
That's on me. Okay. That's on me, Judge. Sorry.
All right, that way you're amplified so that Mr. Cox can hear you.
I can hear him just fine, Judge.
Okay, thank you. All right, Mr. Earlston, just a few preliminary questions for you. Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? Bipolar, PTSD,
ADHD.
ADHD? Are you currently on medication for ADHD?
I am not.
Do you feel like the fact that you're not on medication in any way inhibits your ability to understand the proceedings as they are occurring here today?
No, sir.
And in this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had sufficient time to talk about your case with Mr. Ashmore and have all of your legal questions answered?
I do, sir.
Is there anything about the paperwork that you've reviewed and signed today that you do not understand?
No, sir.
Mr. Ashmore, do you believe Mr. Earlston to be competent today?
I do, Your Honor.
And you've discussed with him his legal and constitutional rights?
We have discussed them at length, Your Honor.
And the decision to proceed before the court today in an open plea, you've discussed the advantages and disadvantages of that decision. Is that correct?
That is correct, Your Honor.
Mr. Earlston, you have been charged with the second-degree felony offense of sexual assault of a child, which is a second-degree felony. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 20 years confinement. The Texas Department of Criminal Justice Institutional Division also carries a potential fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
Now, in this case, it's my understanding that there is no agreement between the defense and the state as to a sentence in this case. However, there is a recommendation that the state's going to make of a period not to exceed 12 years confinement in the Texas Department of Criminal Justice Institutional Division. Is that your understanding, Mr. Earlston?
Yes, sir.
Yours as well, Mr. Ashmore?
That's correct, Judge.
Mr. Cox?
That's correct, Your Honor. That's our agreement.
At the same time, Mr. Earlston, you understand that if the court accepts your plea of guilty today, the court could impose any sentence between 2 years and up to 20 years, and a fine not to exceed $10,000. Do you understand that?
Yes, sir.
You understand that the state's argument or recommendation to the court is not binding on the court. Do you understand that?
Yes, sir.
You understand at this time that since there is no agreement with regards to a specific number of years, if any applied by the court, that you will not be able to withdraw your plea of guilt if the court exceeds their recommendation of 12 years. Do you understand that?
Yes, sir.
All right, Mr. Earlston, then at this time, I'm going to ask you, how do you plead to the second-degree felony offense of sexual assault of a child? Do you plead guilty or not guilty?
Guilty.
Mr. Earlston, are you pleading guilty to that offense because you are guilty of that offense and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this charge?
No, sir.
All right, the court will accept Mr. Earlston's plea of guilt at this time. Mr. Ashmore, is there any objection to States 1, the stipulation of evidence?
No objection, Your Honor.
The court admits States Exhibit 1 and takes judicial notice of Mr. Earlston's judicial confession. Is there anything further from the state?
As far as the adjudication phase, Your Honor, no. We would rest in the adjudication phase.
Thank you, sir. Anything else from the defense with regards to the guilt phase?
None, Your Honor.
All right, and Mr. Ashmore, it's my understanding that you're going to call a couple of witnesses today.
Yes, Your Honor. I also anticipated the state was going to call one witness. Am I mistaken?
I believe Mr. Cox indicated there's no witnesses from the state.
That's correct, Your Honor. We had subpoenaed a witness. We had discussed having her testify. However, some information came to light that I made Mr. Ashmore aware of, and because of that, we are not going to be calling that witness to testify. As far as the punishment phase is concerned, the state would just ask that the court take judicial notice of the pre-sentence investigation report and judicial notice of the offense report contained in State's Exhibit 1.
Okay. All right, then, based upon the evidence presented to the court, actually, I'm going to take just a moment to review this stipulation a little bit further. Just one moment. Bear with me.
Yes, Judge.
Based upon the evidence presented to the court will find that there is sufficient evidence to convict Mr. Earlston of this offense. By convicts Mr. Earlston of the second-degree felony offense of sexual assault of a child. All right, State, are you ready to proceed in the punishment phase?
We are, Your Honor.
All right, do you want to make an opening argument at all?
Judge will waive opening statement.
All right. The court will take judicial notice of the pre-sentence investigation report filed in this cause, and the court will also take judicial notice of the stipulation of evidence presented during the guilt phase. Anything further from the state?
No, Your Honor, we would rest in the punishment phase as well.
Mr. Ashmore, any opening argument?
Just briefly, Your Honor, Mr. Earlston clearly is here penitently accepting responsibility because of the state's expeditiousness in this punishment phase. We will reciprocate. We're only going to call one witness. We're asking the court to consider the fact that Mr. Earlston is still a young man, has never been convicted of any prior offense, and keep an open mind and an open heart with regard to the full range of punishment that it is the court's discretion to consider. Thank you, Your Honor.
All right, Mr. Ashmore, I'm going to call your first witness.
The defense would call Trista Earlston.
Mr. Earlston. Mr. Earlston, if you'll just stay right there. And if you'll step over this way a little bit. Raise your one. Raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? If you go ahead and have a seat. All right, just a few tips on your testimony today, okay?
Okay.
Mr. Ashmore is going to ask you a series of questions. Let him fully ask his questions before you try to respond. You may anticipate what the answer is going to be. A court reporter here to your left, she's going to take down everything that we're saying today. It's very difficult for her to type down what two people are saying at the same time. It's natural during our conversations to want to maybe answer before, because we're trying to be polite. Allow Mr. Ashmore to fully complete his question before you answer. He's going to extend that same courtesy to you that we're not talking about. So if you see either one of the attorneys object or say objection or stand up, just stop your testimony. And finally, if we hear any emergency vehicles or loud trucks that flood the courthouse, let that sound pass if you're testifying at that time, so that the court reporter can hear, the state can hear. But Mr. Ashmore.
Thank you, Judge. Ma'am, can you please tell the court your full name?
Trista Earlston?
And we met today, correct?
Yes,
You have known me via some telephone conversations in the past weeks and months.
that's correct.
You weren't promised anything in exchange for your testimony today,
No,
and you're fully aware of the allegations against Christian.
yes, I am.
And despite the nature of those allegations, you're here in support of him,
Yes,
and you're here to lift him up as best you can as a family member.
that's correct.
And just so we're clear, how are you related to him?
He's my nephew.
And there are other members of your immediate family here to support Christian,
Yes, my daughter.
your daughter, and anyone else,
His mom
and anyone with his mother.
and her husband.
And do you get the impression that those family members are also aware of the serious nature of the allegations regarding
Yes.
Christian?
Yes,
And again, you're all here simply to lift him up in this challenging time.
that's correct.
You think if I asked them the identical questions I asked you, their responses would be substantially the same?
Yes,
Judge, nothing further from the defense for this witness.
Any questions from the state?
No, Your Honor, I have no questions.
All right, thank you, Ms. Ralston. Mr. Ashmore, any additional witnesses?
No other witnesses, Your Honor.
And Mr. Ashmore, have you had an opportunity to receive and review the victim impact statement in this case?
Not, Your Honor. My understanding is that unless it's got something mitigating or exculpatory towards my client, that is a privileged confidential document, as it would come out in a regular punishment hearing with a live witness. So I think that's the court's call on an in-camera. And if not, I'm going to blame it on Jason Niehaus because I called him right before this hearing. Got squared away on that. But I haven't seen it. But I did check the law on that, and I think unless there's something exculpatory or mitigating that we need to be aware of.
The only reason I ask is I inquired of the state if there was a victim impact statement. And before I reviewed it, the state had indicated through one of their representatives that the victim impact statement is made available upon request to the defense. So I think what I'd like to do is, if that's the case, that's the state's policy, as was told to me by the victims coordinator. And I believe I would like you, Mr. Ashmore, and Mr. Earlston, to have an opportunity to review and read that. And then that way you can address any issues in there or cover that in your closing argument.
We would appreciate that.
All right, and Ms. Heisel, can we make that available to Mr. Ashmore since you're present?
Your Honor, I know you had a conversation with Ms. Cheney. It is our understanding after further review of the code that is not discoverable information absent the judge finding something exculpatory in the statement upon his review. I can get you that code section. If you order us to produce it, we have it available, but it is our understanding that that is only to be turned over to the defense in the event that there is exculpatory information involved in the victim impact statement.
So that's not the DA's policy to provide that.
That's correct, Your Honor.
So the information I received was incorrect.
Correct, Your Honor.
Okay. And the state has reviewed the victim impact statement before providing it to the court.
Yes, Your Honor. I have not personally, but I believe Mr. Cox has, and I know that Ms. Cheney has kept a proper log of that.
Okay. And upon the state's review, there's been no determination that there's anything that would constitute Brady or Morton evidence. Is that correct?
That's correct, Your Honor.
Okay. All right, then the court will stand in recess on this case and will review the pre-sentence investigation report, and we'll consider the stipulation of evidence and the other testimony before the court for rendering a sentence. So I'm going to recall your case in just a short bit, Mr. Earlston, okay? All right, so you can have a seat back in the jury box. Anything further? What we'll do is, I'll tell you what, let's do this. Go ahead and have a seat, Mr. Earlston. I'm sorry. I've done this both ways. I've either taken closing arguments now or I've taken them shortly before we take a break. Let me go ahead and take closing arguments now at this time. So, Mr. Cox, do you have any closing arguments?
Judge, I would waive my opening closing argument and reserve for a rebuttal.
Okay. Mr. Ashmore, closing argument.
Well, Your Honor, I would appreciate an opportunity while you're on recess to triple check that section of law, just to make sure I'm square on that. But I think we're all squared away on it. But would appreciate an opportunity to have a moment to pause and revisit that. You've heard our opening statement. Our closing argument is essentially the same plea for mercy. This is a horrendous offense, and it couldn't be more serious for this young man. And we're asking the court to find mercy and help Christian based on the facts that are before it. the support and the love of his family. He's not alone in this world. Thank you, Honor.
All right, I will allow the defense to reopen its closing argument if there's some discovery regarding the victim impact statement that you believe needs to be brought to the court's attention regarding that. Otherwise, the court will stand in recess. And so it's my understanding that I've not heard an argument for any specific amount of time from the state. I've read the cap of 12. To my understanding that there is no recommendation. There's no specific recommendation from the state.
Judge, we are going to ask the court for that 12-year sentence.
And is there a request from the defense?
Respectfully, Judge, we would request that that sentence be less than 12 years, given the arguments presented and the evidence you've heard.
All right, the court will stand in recess on this case, and we will reconvene for the court's sentence. Counsel, you bring to my attention if there's any other issues that need to be brought up before we continue, okay?
Thank you very much.
Mr. Olson.
Yes, sir.
Have a seat, Mr. Olson.
May I be excused?
Yes, you may. Mr. Monty, Mr. Elliott. Do you need the court's attention? Do you need the court's attention? All right, I'm going to stand in recess for about 15 minutes, and we'll resume. Is Mr. Green going to be ready? Do we know on Ms. Red and Mr. Palmer?
I believe that Mr. Green and Mr. Cox have been communicating.
Okay, I don't see Mr. Green, so we'll stand in recess for 15 minutes.
All rise.
All right, Mr. Palmer, if you'll make your way to the podium. All right, this is cause number CR 15487, State versus Sean Anthony Palmer. We're set for hearing today on the motion to adjudicate. Any announcement from the state or the defense?
Your Honor, I believe Mr. Green and I have reached an agreement on this case. We're going to continue Mr. Palmer on probation. We're going to add a condition to his probation, however, that he continue to receive outpatient drug rehabilitation treatment, which he has been doing prior to today. Mr. Palmer has had, I just believe, one slip up as far as a positive UA goes a while back. But it's my understanding from Mr. Green, he has been going to outpatient treatment and has been doing quite well. So the state is okay with this resolution.
And Mr. Palmer, if I drug test you today, you're going to be clean. All right, so I'm going to recall your case. I'm going to have a UA administered today. And if you are negative, then the court will consider that. Okay. So go ahead and have a seat. All right, Mr. Green, are you ready on this red?
Judge, I do have an announcement, a preliminary announcement that is not necessarily an announcement of ready, but one that I think we can discuss. And I visited with Mr. Carson today.
Is that something we can take up now? Or?
I think it can.
Okay. Go ahead and Bailiff, will you bring that podium up so Mr. Green can make use of that and that microphone there. You can move your on in just a little bit more so Mr. Cox can see. There we go, sir. Go ahead, Mr. Green.
Do you want Ms. Red to hear?
No, she's fine right there. This is CR 15503, State versus Tanya Louise Red. Go ahead, Mr. Green.
Judge, we're set on a motion to adjudicate this morning as well on Ms. Red. She is under the impression that because she has been diagnosed with some mental health issues, that she is entitled to have a MHMR court hear her case and resolve her case. I've explained to her that I've researched that issue, but that's just not the case of the law in Texas, unless it is a specific county that has an MHMR court. And I think she just needs to hear that from the court as well.
Do you believe there's any issues with her competency, Mr. Green?
No.
Okay. Right, then the court, for the record, would inform Ms. Red that the Van Zandt County does not have any specialty courts, be that MHMR, veteran, drug court. There are no specialty drug courts created either by statute or by local order in Van Zandt County. At most, the court has made use of the Sanctions Court program to address issues related to MHMR, veteran issues, drug issues, and I believe that Ms. Red has been in that program before this court for sanctions. So there is no MHMR court in Van Zandt County, and there's no provision that this court's aware of that requires a screening or any type of assistance program to those who believe that they have been diagnosed with some type of mental condition by the MHMR agency or any others.
Okay. And with that said, Judge, if we could recess this hearing for a little bit and let me visit with Ms. Red, and we'll either have a resolution or we'll be ready to proceed with the hearing on the motion to adjudicate.
Yes, sir. The court will recall Ms. Red's case, and counsel, you'll just let me know when you're ready.
Yes, sir.
Just for the record, it is 11:45. The court will recess at noon. If we do not, if we're not able to complete our business by noon, then we'll recess and recall after lunch. The court does have 2 civil hearings set this afternoon, 3 and 4, just to put everyone on notice.
Yes, sir. Thank you, Tom.
Mr. Ashmore.
Yes, Judge.
We're back on the record. CR 20116, State versus Christian Earlston, and you just stay there, Mr. Earlston. I believe I failed to. We discussed the pre-sentence investigation report previously. Well, it was brought up in discussions. I don't know that we discussed it. I believe it's incumbent upon me, Mr. Ashmore, to ask you if you've had the opportunity to receive and review the pre-sentence investigation report prepared for Mr. Earlston in this matter.
Yes, Judge. In fact, I think we've had that for a little while. This is
And by when you say a little while, can you give me more concrete, like
in the last 4 weeks. In the last 4 weeks,
okay, so,
Mr. Cox actually let me read the initial report, and then the probation department has emailed us the completed, finalized. So I've seen both. If there was a draft, I've seen the draft and I've seen the completed version.
any objections to any of the information or requests for additions or modifications in that report?
Not really, because this, I can't keep up with the legislature and where they recodify 3G, but this is not a probation deferred eligible offense. It's just not. The court can't do it. So while a PSI is required in this particular scenario because of 22011, the offense that my client's charged with, and the way they've recodified 3G under 42 and whatever other number it's under now. And I'm sorry, I can't keep all those straight, but it's not one the court can consider from the bench. So the report's helpful and appreciated, but what impact it has on today, I think is limited. If we're talking about probation eligibility and things of that nature. Beyond that, it is helpful in that it gives some insight as to what probation thinks that my client would be a candidate otherwise for a probated sentence, et cetera. But that's just not something the legislature permits this court to do in this scenario because of the charge.
Had this court not accepted and found Mr. Earlston to be guilty of the offense, the court could have deferred a finding of guilt in this matter, correct?
No.
No? I believe so. Mr. Cox, do you agree or disagree?
Judge, Mr. Ashmore and I have discussed this, and he and I have to agree to disagree on this one because it is my understanding, and I may be wrong, but it's my understanding that the court could defer a finding of guilt in this case and place Mr. Earlston on probation. I don't have my code book in front of me here at home, so I'm not able to look it up. But again, I would respectfully disagree with Mr. Ashmore.
Judge, if I could maybe offer some clarification, and not that Mr. Cox is wrong, because we have had some intellectual exercise about this for the last 4 or 5 months, but unless the plea offer includes a deferred, so the way that this can happen under 22011, and as I understand Court of Criminal Appeals most recent case law on how we're doing 3G now, if the plea offer includes deferred, the court can consider it. Otherwise, it cannot. It's not one the court can do from the bench. And there's another facet. If I could have a moment, I've got a case, Judge.
Yes, sir.
Okay. Judge, I'm sorry. I'm gonna get my case law straight. Probation, straight probation from the bench, not eligible. Deferred can be permitted if it's part of the plea offer from the state, but the court has to make a finding in open court that would be in the best interest of the victim. So forgive me for that misstatement. I just got those two confused. That's the only way that, as I understand the recodification of 3G and the case law interpreting it. So we have to have, one, it's got to be part of the plea offer. It never was. Two, the court has to make a finding it's in the victim's best interest. Got to be a finding made in open court on the record. And then alternatively, can't do straight probation from a bench trial.
Any other issues in the pre-sentence investigation report? I will note that upon my review of it, there was some information that regarding Mr. Earlston's diagnosis with mental conditions disclosed in the PSI that was not discussed today. Specifically, he said that he was diagnosed as being bipolar while in school. That was not discussed during our plea today.
No, Judge. I think he testified that he was ADHD, or attention deficit disorder, which is, in my conferencing with his family, is their recollection and understanding that he does have a diagnosis for attention deficit disorder. And I think this did actually come up the first time when we had the jail docket, when the court asked if he was on any medication or current treatment for that. So I don't, as I understand it, I don't believe he's under the care of any mental health or medical care provider for those issues. Not saying they aren't there. They aren't part of his past. He's not under any current care that I'm aware of.
What about from the state? Any requests for additions or deletions, modifications to the PSI?
None of the above, Your Honor.
So it's my understanding that Mr. Earlston does not have any criminal history, no convictions.
That's the state's understanding as well.
All right, Mr. Earlston, if you'll come have a seat at the table.
Your Honor, before we proceed, if the state would be allowed to readdress one thing on the record.
Regarding Mr. Earlston?
Regarding the victim impact statement as it relates to this case.
We'll let Mr. Ashmore have a seat. Go ahead, Ms. Heisel.
Thank you, Your Honor. Previously, when we spoke about your communications with Ms. Cheney during the break, I spoke with her, and when the court contacted her, she was under a misimpression that had been requested by the defense, which would spur the proceedings that we talked about earlier with the so any misinformation or misunderstanding was not intentional. I believe it would be the result of a miscommunication as to what the policy was, and she informed the court as her responsibilities as a victim coordinator without regard to what the attorney's responsibilities were in court. And to that end, in compliance with Code of Criminal Procedure Section 5603, since the guilt has been adjudicated, Your Honor, we have permitted the defendant and his attorney to review the victim impact statement after making sure that there was no information required to be redacted by law, and that has been completed prior to the announcement of sentence.
And in my review of the confidentiality regarding the victim impact statement, my discovery is that the only thing that's confidential about the victim impact statement is the contact information page. Is that correct?
That's correct, Your Honor. So we provided him the statement, but not the contact tracing page.
Okay. And so, Mr. Ashmore, you've had an opportunity to review that victim impact statement?
Yes, Judge. We've had an opportunity to review that with Mr. Earlston, and we appreciate the court's time. And I think we were all just operating under the two pieces of information that we thought the whatever statements would be coming live either via Zoom or with a witness. And when we all double checked this statute, the state immediately allowed us the opportunity to get a redacted copy and visit with our client about it. And we appreciate the court allowing us the opportunity to do that.
And after reviewing that, is there anything else you feel like you need to address with the court?
I would just reiterate our request for mercy for Mr. Earlston in light of everything that the court has heard today and read today, the ESI, as well as the victim impact statements. Thank you, Your Honor.
And Mr. Earlston, is there any legal reason, to your knowledge, and Mr. Ashmore will assist you, is there any legal reason that sentence should not be posed against you today?
I'm not understanding. Stop sentence. No.
Okay, thank you, sir. All right, then the court, based on the evidence that has been presented to it, court has reviewed the stipulation of evidence, which was submitted during the guilt phase of the plea hearing. On reviewing the indictment, the offense report from the Van Zandt County Sheriff's Office, court has also taken notice and reviewed the pre-sentence investigation report prepared by the Van Zandt County Community Supervision and Corrections Department. Court finds that there's limited information for the court to really mete out a sentence that is not somewhat, I would say, arbitrary. The recommendation from the state is 12, with the only evidence supporting that is the offense report. Really just the offense report. There was no testimony provided by no evidence, only other evidence provided by the state. The evidence and testimony provided by the defense by way of Ms. Earlston was really of no evidentiary value to the court. The recommendation of 12 from the state and a recommendation of mercy and less than 12 from the defense, the court has resigned itself to deciding, based on the information provided in the pre-sentence investigation report, what it believes would be a just sentence for Mr. Earlston. And I will commend you, Mr. Earlston, for accepting responsibility for your actions in this cause. There's been many that have gone before you that have refused to do that, and they drag their victims to court. They require them to testify. They require them to relive the incident, and that causes more harm. Causes more harm to the victim, to the victim's family, to those associated with the incident. So I will commend you on doing that, Mr. Earlston. The court also finds that you have a lack of a criminal history that would be aggravating to the court in determining this sentence. The court also knows that you're a rather young man. You are only 22 years of age. One might argue that you would not have enough time to develop a criminal history yet. I've sat here throughout my career, and I've seen many people of your age be arrested and convicted of many offenses by the time they're 22. So the court has put consideration and weight into the fact that you do not have a criminal history and that you are a young man. The court has put great weight on your accepting responsibility for your offense here today. The court also knows that a conviction and sentence in this case is going to bring with it a lifetime requirement to register as a sex offender. And that's something that the court does not take lightly, as it is a lifetime requirement for this type of offense under Chapter 62. And Mr. Ashmore, I'm going to presume that you've discussed that issue with your client as well.
That's correct, Your Honor. We have.
Mr. Earlston, then, based on the evidence and the court's weighing of these things that I've just informed you of, the court is going to assess your sentence for the second-degree felony offense of sexual assault of a child at 8 years confinement in the Texas Department of Criminal Justice Institutional Division, and the court will assess a 0 fine in this matter. Mr. Earlston, you will be given credit for any time that you have spent in jail on this cause, and I would direct the state to assist Mr. Ashmore in compiling how much credit time Mr. Earlston has provision on the court finds that after 62 does apply in this case, the court would ask the state to provide Mr. Wilson 62, or will require Mr. Rolston to complete the sex offender admonishments and to submit that today at the same time that we receive the judgment. And Ms. Heisel, do we believe that we can have that done before noon, or should we have Mr. Rolston brought back to section?
Judge, I believe that by noon would probably really be pushing it. I know Miss Abney is standing by waiting for the court's decision. We could have him appear back at 1:30, or if that's our only thing after lunch. I don't mind taking that judgment out to the jail so the transport does not have to come back to the
Let's do this. Can you provide Mr. Ashmore with a copy of the Chapter 62 admonishments? I'd like Mr. Ashmore for you to stay and to go over that with
Absolutely, Judge.
Mr. Earlston. I don't know if you're available this afternoon.
We'll be available.
If not, if you need to appear via Zoom, the court would grant that for purposes of entering the judgment to make sure that the information is correct. But I would like you to in-person visit with Mr. Earlston regarding the sex offender registration requirements.
Absolutely, will, Your Honor.
All right, Mr. Earlston, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. From this day, as you go forward, I hope that you continue to try to make amends for the crime that you've committed, for the harm that you've caused to your family. As I said before, I know your family, and I know that they do, believe in forgiveness. So that's something that you will be able to work towards. It'll be theirs to give, but it'd be something that you can help them with. Okay. So, hereby remanded to the custody of the sheriff. We will arrange for your fingerprinting momentarily or this afternoon. Okay. So I'm gonna have you have a seat over here with the deputy. Anything further in this matter, Mr. Ashmore?
Not until so 1:30 docket, but we need to go over the admonishments beforehand.
Ms. Heisel, I believe, is making arrangements to have the sex offender admonishments.
And I'll coordinate with her office and get that handled, Your Honor.
Okay.
Please.
And if you can get that done before noon, and if you need to leave, then you can appear via Zoom whenever the state provides the judgment and make sure that that's all correct. And just for you don't have to be here for the fingerprinting, but I do want you to go over the admonishments with him. So if he has any questions,
Thank you, Judge.
okay.
Are we excused for
Yes.
this?
All right, we'll stand in, I guess, in recess. I'm not going to leave the bench, but we'll just stand in recess until Mr. Green's available. We have an update on Mr. Green.
I'm going to take it out. Grab Mr. Green.
understanding that the agreement is to adjudicate Ms. Red today, convict her of the second-degree felony offense of possession of controlled substance, to assess her punishment at 10 years confinement in the Texas Department of Criminal Justice, to suspend that sentence, place her on community supervision for a period of 10 years with SAFE-P as a condition of community supervision.
That is, Your Honor.
I noticed that the SAFE-P is contained in the conditions of community supervision. It's not reflected on the judgment adjudicating guilt. Is that the state's intent?
We saw that, Your Honor, and as long as it is contained within the conditions of probation and it is on the record, I believe that would be fine.
And Mr. Green, you've spoken with your client about that requirement, although it's not reflected on the judgment, that it would be in the conditions as part of the agreement.
Judge, that has been the one issue that we have spoken with about almost exclusively. So she does understand.
Can I have you complete this document right here? Trial court certification. Just
I didn't see that.
go over that with her so she understands.
I'm sorry, I can't see very well. Could I see that? I'm sorry. Could you just give me an approximation? The length of the SAFE-P is 6 here.
Sorry about that, Judge. I missed that and all the others.
All right, Mr. Ed, just right where you're at. You don't have to stand up. If you will, just raise your right hand. Place you on your oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can change. All right, Ms. Red, the court heard evidence on May 19th of 2019 and accepted your plea of guilty to the second-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams. The court found that there was sufficient evidence to convict you of that offense on that date. However, the court deferred a finding of guilt and placed you on community supervision for a period of 5 years. That was pursuant to the plea agreement you reached with the state. It was during that term of your community supervision that the state has filed its second amended motion to adjudicate and revoke community supervision. In this second amended motion to adjudicate, the state has alleged in 7 separate counts various ways they deem you have violated your terms of community supervision. You had an opportunity to review this with your attorney, Mr. Steve Green.
Yes, sir.
You feel like you've had sufficient time to discuss the case with him and have all of your legal questions answered? Are you pleased with his representation of you?
Yes, sir.
Is there anything about today's proceeding documents that you have reviewed and signed?
So I understand.
Okay. Mr. Green, does your client waive the formal reading of the state's motion to adjudicate?
She does, Your Honor. But enter a plea of true to each count in that motion.
All right, Ms. Red, as to counts 1, 5, 6, 7, how do you plead to those counts? Are those counts true or not true?
The counts are true.
Ms. Red, are you telling me that the counts are true because in fact they are true and not for any other reason?
Yes.
And has anyone threatened you, forced you? You had to plead true to any of these counts.
Yes.
The court will accept Ms. Red's plea of true to the counts as alleged. Mr. Green, is there any objection to the admission of the defendant's waiver of rights and plea of true?
Oh, Your Honor.
Court admits the defendant's judicial notice of Ms. Red. From the state,
Welcome to stage, Judge. We rest and close.
can you repeat that one more time?
Nothing else from the state, Your Honor. We rest and close.
Anything further from the defendant?
Judge, just one thing, and I visited with Mr. Cox about it yesterday. No, it's not the state does not agree to this request. I advised Mr. Cox yesterday that I would please that we ask the court to release Ms. Red pending bed becoming available for safety. She understands it is not part of the agreement. The court has discretion on whether to grant her request or not, but do just make that clear.
All right, the court, in considering that request, also considers the past hearings that we've had in Ms. Red's case. The court's going to deny that request at this time.
Thank you. Other than that, Your Honor, we have nothing else.
Ms. Red, we've been doing this dance a long time.
Yes, sir.
You know, we've gotten familiar with one another during sanctions court. Seen some positive progress out of you, Mr. Palmer. Obviously, this is something that has a hook in you. This is an opportunity, I believe, that you've seized. And I know as you sit there, you're worried about your kids, worried about missing them over the holidays, you're worried about missing your husband. Know that this is serious. I understand that. What I think is also just as serious is if you don't address this problem now, it's a lot more than one Thanksgiving or one Christmas, one birthday. So as you sit there and I'm sure you're in a depressed state, I don't blame you. Understanding where we've been, cases, where you're going in your case. Today, you've taken responsibility for violating your community supervision. The court could have rejected this plea agreement, and the court could put you in prison up to 20 years. The state's not asking for that. The probation department has never asked for that. Everyone in here wants you to succeed. Giving you that opportunity. I'm going to resign myself to the fact that your drug addiction has been controlling your decision. That's not you. That it's this control that drugs have over you. And given another chance, albeit it's not what you wanted today. I understand that. But I want you to know when you leave this courtroom today that this is a blessing in disguise for you. It's disguised as something that you resent, that you don't want. You believe that you can beat this drug addiction on your own. However, from where I sit, I don't believe that you can. And I'm glad that Mr. Green and the state and you have all decided that given another opportunity. And I hope that when you go down to the substance abuse felony punishment facility, that you will accept it for what it is. A chance to learn how to mentally deal with this addiction that you're going to live with possibly for the rest of your life, most likely for the rest of your life, because there's still such a big weight. There's a big hammer that's going to be hanging over your life. When you get out of safety, you're going to be on probation 10 years. And you know as well as I do that probation is not easy. It is not easy. I say this all the time. It's easier to be locked up. It's easier to be told when to go to bed, when to get up. It's easier to do that than to be a responsible adult, to get a job, to do your community service, to pay your bills, to fight your drug addiction, maintain your education. Those things are harder. And there's no one there. There's no one there to make sure that you get fed, that you get heated, you get cool. You get all those things at the cost of your freedom. Get down there that the only reports I get back are that you're taking advantage of what can you learn, so that when you get out and you're back with your kids, that you're back with your husband, that you're back at your job, that you've learned something and that you've become a better person and that you are fighting your addiction to stay clean, so that we don't come back here, so that we don't have this discussion anymore about how many birthdays are you going to miss, how many Thanksgivings, how many Christmases. That's something that no one wants. I don't want to be put in that position either. Understand?
Yes, sir.
So the ball is put back in your court. It was in your court, right? And you let it go out of bounds. Okay? We're going to inbound it back to you. Now you've got it and you can dribble with it.
Yes, sir.
What are you going to do? Are you going to go towards your goal? Right? Or are you going to go the opposite way and turn it back over? Right?
I'm just going to go towards God and my husband and family.
I can't think of a better plan. And if you do it in that order, I can't think of a better plan. Okay?
Yes, sir. Thank you.
All right, Ms. Red, then based on your plea of truth and the evidence before court hereby finds that there is sufficient evidence to convict you of this offense. The court does convict you of the second-degree felony offense of possession of controlled substance of penalty group 1, greater than or equal to 4 grams, less than 200 grams. The court, in accordance with the plea agreement, finds that it would be in your best interest and the best interest of the community for you to be continued on community supervision. The court does assess your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, but does suspend that sentence and places you on community supervision for a period of 10 years. The court hereby orders you to serve a term of confinement in the Texas SAFE program, that is the Substance Abuse Felony Punishment Facility, in addition to the other terms and conditions of your community supervision. The court orders you to continue to pay your financial obligations, including court costs. Is there anything further from the state?
Your Honor.
No, Your Honor.
All right, I didn't realize I was on mute. Rest and close, Your Honor.
All right, Ms. Red, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. I'm going to have you step forward here, meet my bailiff to get fingerprinted.
Your Honor, that's all my business. May I be excused?
Yes, thank you, Mr. Green.
Have all the paperwork. I'll check to see if they're finished reviewing it.
Mr. Green, we do need to address Mr. Palmer. We need to do a reset. You were asking for a reset, is that correct?
No, it's a final resolution.
Okay, do we have paperwork on that?
I don't think we're amending anything, so it's just, Mr. Cox can correct me, the state will be dismissing the motion to adjudicate on Mr. Palmer.
That's correct.
Okay.
Now, I did think, Steve, we were going to do a modification, adding the outpatient treatment as a condition, though, right?
If we need to, I assume that it was already in there, but if it's not,
Then we don't need to enter anything.
Perhaps we can check on that.
I mean, all we'll need to do is, if it's not in there, just the modification
Just amend the condition. Mr. Palmer, come on up. Mr. Palmer, we're just checking to see if you already have conditions in your community supervision that requires outpatient, that you continue with your outpatient drug rehabilitation. Do you know off the top of your head if you do? And Officer Matura, she's going to verify for us. If that's the case, then it's my understanding that the state's going to withdraw their motion to adjudicate. And once I get confirmation from Officer Matura, if that's the case, then you'll be free to go.
Thank you, Judge.
As far as I see.
That's the agreement, Mr. Green. So, Mr. Cox, what I overheard was that he's not a part of a outpatient drug rehabilitation program. He's attending counseling.
Yeah, right, through the probation office.
And is that the state's agreement to withdraw and just let him, so basically just withdraw and continue?
Yes, sir.
And are there any new court costs or anything that he's going to be amended to pay?
Not that I'm aware of.
Usually, is there usually a $50? Right. Court costs, so we're just going to. All right, Mr. Palmer, you're free to go.
Thank you, Judge.
Excuse.
Yes, sir. Judgment. Yes, please. All right, Mr. Ashland, we know that the state provided Mr. Earlston a copy of
They did, and he asked me for
Hi, Mr. Earlson, if you'll come on down. Have you be fingerprinted by the bailiff?
Judge, I have one more document.
Right, just in regards to CR 2116, versus Christian Knight, Earlston, court will have the recollection of Mr. Wilson has provided a copy of Chapter 62 of the Texas Code of Criminal Procedure as submitted to the court. Punishments. Has been fingerprinted in the state. Anything further from you, Mr. Ashmore?
Matter that we can take off the record, just out of
Okay.
a little cost.
Okay. Anything else further from the state?
I believe so.
Conclude our criminal docket for today. Hope you all have a happy Thanksgiving.
Thank you, Judge. You as well.
Yes, sir. You want to approach on your
Yes.